Last time we talked about the 4 steps to becoming a responsible non-subscriber. The first step, of course, was to exit the comp system correctly. The next step was to secure a policy that would cover the medical benefits and disability benefits for your injured employees. And step 3 was to secure an ERISA document that explained those benefits. So what we're going to talk about today is the ERISA, the policy, and how they work in relationship to each other. And I want to make this clear. There are really 2 contracts at play here. The first contract is the policy. That is the contract between the insurance company and the employer. And most of the policies that we offer in the marketplace today are for $1 million. Now that $1 million is available for a period of 2 to 3 years. So you've got 2 limits here. You've got the dollar limit, you spend all the money, it's over, or you run out of time and it's over. But that is the contract between the insurance company and the employer. The ERISA is a whole different contract. That's the contract between the employer and the employee. So quite often, even though they both come from the same carrier, they both come in the same package, they're not going to be the same. And let me explain why. If you have a policy for $1 million, what that means is the employer calls up the insurance company and says, I had an injured worker. The insurance company, in theory, of course, not in reality, says, here's a bucket with $1 million in it. You've got 3 years to spend it. Go, have fun. You can spend it on medical bills, you can spend it on disability, you can spend it on accidental death and dismemberment. Just go for it. That's yours. That's what we contracted for. It's yours. But there is a $1,000 deductible. So let's make sure we get that in there. The deductible is $1,000. Now it can be more, but the vast majority of the policies have a $1,000 deductible. Believe it or not, we've actually sold some policies that had $500,000 or more of self-insured retention or deductible. And that's a whole other discussion we can get into at some other time, the difference between a deductible and a self-insured retention. But basically they mean the same thing, but we're not going to go into that now. The ERISA, on the other hand, is probably going to say $250,000. Now, why would they be different? Well, this is why. You want, as an employer, since you are the plan administrator, you want some point where you can go to that employee and say, I have fulfilled my obligation under the plan. In other words, I promised you medical benefits, I promised you disability, I promised you accidental death and dismemberment, and I delivered. I did everything I said I was going to do up to $250,000. I'm finished. Okay? Now the reason you want that at $250,000, consider you had a very, very, very serious injury. Okay? And you didn't have this $250,000 limit in there. No ERISA whatsoever, just the policy. Okay? You have spent the whole $1 million on medical benefits and disability, and now you've got no money left. And then you get sued. Have you got any money to settle that case with? No, you don't. That's why you want the limit. So that even though the man needs more, you have that point where you can go and say, I have fulfilled my obligation. Okay? We know you need more. Okay? So what are we going to do? We're going to take from this and provide that more that you need, but I want you to sign a release. Now there are some laws, and we're not going to go into all of them. The main one you need to know about is you cannot offer a settlement for a release until at least 10 days after the date of the injury. Just a little thing to keep in mind. It doesn't often come into play, but you might run into it one of these days. So we go to the employee and we say, we have fulfilled our obligation. We need to settle this thing right now so we don't have to go to court. Probably the best example would be the worst type of injury you could think of. Young man, mid-30s, paralyzed from the waist down, his wife doesn't work, he's got 3 kids. You know, he's not going to work in that job the rest of his life. Well, we had a situation like that. It was a different carrier, and carrier is irrelevant. But they had a $100,000 ERISA limit. So they got to $100,000. I mean, the kid's stable. He's going to live another 40, 50 years. He's just paralyzed from the waist down. So what are we going to do? So they went to him and they said, okay, we know you need more. So what we're going to do is we're going to offer you $300,000 in an annuity where you can get a check for the rest of your life. is there anything else you need? And the guy said, well, my wife needs to have some kind of training so that she can go get a job because the annuity is not going to be quite enough. Okay, so they said, pick your school for a technical school, we'll send you. We'll pay the tuition and we'll cover that cost. 3 kids all got $25,000 each in a trust fund for their college education, and said, is there anything else you need? And the guy says, my car is about to break down, we'll buy you a new car. Is that fine? Good, sign here. Claim is over. If you've ever been in the claim business, you know that the only good claim is a closed claim. So the sooner you can get it closed, the better. So that's why you're going to see that the policy is different from the ERISA. Now, every carrier is a little bit different in whether the duty to defend is totally outside, somewhat inside, maybe not all outside, and what does it take away or does it not. But for the most part, you can get by saying the duty to defend is outside the policy limits and does not erode the benefits on the vast majority of the policies. So that's basically the difference between the two. Very important to have this, okay? But it's also important to understand the difference. And you need to pass out the summary plan description of the ERISA plan to each and every employee and make it part of your hiring packet. Next time we're going to talk about mediation binding arbitration.